I think there's some subtests you can do for history. That wouldn't be in the standard battery, but I can look into that. I think there are.
Because I had one. Hi there. I'm Maggie Gainey. I'm a clinical psychologist with Spartanburg Regional Family Medicine Residency Program, but I'm currently the interim executive director of Mental Health America of Spartanburg County. And we're here today for our March Ed series with Andrea Moore. She's going to be talking with us about working with guardians at Litem and Family Court, and really looking forward to that. Before we get started, before I hand it over to Andrea, just a couple of logistics. We have a couple of events coming up. The Be Kind to Your Mind event, which is May 4th at Harvest Park, Northside Harvest Park, which is where the farmers market is, from 5 to 7. We hope everybody will come out for that. It's a fun time. We have food. We have games and stuff like that for the kids. We will have the mayor come and do the mental health proclamation for the month of May, as well as some artists from Dorman High School who will be presenting their art that's mental health themed. So it's a really good time. And then we'll be honoring some folks in the community who are mental health advocates who have lived experience themselves. So we hope that you'll come out and support us with that. The next Ed series will be in May as well, and you should be receiving information about that in April. So please be on the lookout for that, or you always can look at our website, which is majspartanburg.org. Lastly, if you are wanting continuing education credit for today, all we need you to do is go to do a Survey Monkey survey that'll basically link you to Elaine Swain at Spartanburg Regional, and she can get you set up with that. You'll have to pay the $15 fee and then get your certificate that way. I will put her information as well as the Survey Monkey in the chat during the talk. And if you have any questions at all, please feel free to put a comment in the chat, or there's also with the Zoom webinar, we have the capability to do Q&A, question and answer, and I'll be monitoring both of those throughout the talk. So, all right, I'm going to turn it over to Andrea.
Awesome. Thank you. So we are trying to do this hybrid, and I have some people here in person as well as those of you who are appearing virtually. So if I'm looking up and away like this, I'm looking in the room, and I may be looking down to you. Forgive me if it is a little awkward, but we're going to do the best to be able to make sure that everybody can hear and see and engage. So I'm Andrea Moore. I am an attorney. This year will actually make 25 years that I've been in practice. Which is kind of remarkable to me because I feel like I should still be 25, but that is how it goes. I have been doing exclusively guardian work for maybe a dozen years of my practice time, but I also took a 5-year break from practice to work at the Middle Tiger Community Center about 12 years ago. And so I had the privilege during that time of working with some really fantastic counselors for children and adolescents. I know a lot of you know those folks I'm talking about, and I was able to learn a lot and gain a lot of skills and resources that when I came back to practicing law and doing guardian work that I was able to bring back for the benefit of the kids I work with. So I'm really thankful for that opportunity. So I've got a lot that I'd like to cover, and I'm going to go through some of it very quickly so that I can spend more time on the things the more substantive things. I do want to say at the outset, if there's time at the end, there's several things I put on the list of discuss if there's time, and there's some things that I'll spend more time on at the end if we have time to go back. But also, I'm easy to find. Google me. Call me, email me. I'm happy to speak to you. I'm happy to continue the conversation or answer any questions you all have anytime. So glad to hear from you. So let me start with just sort of an overview of what guardian ad litem is. So there are two kinds of guardians ad litem. I am an attorney and I work in private custody cases. And so it is parents, maybe grandparents, other people fighting over custody or visitation regarding children, people who don't agree about what is in the best interests of the children. And maybe it is, maybe it's a couple getting divorced and one of them wants to have equal time, week-to-week schedule, and the other one wants to have primary custody with the other parent getting every other weekend, more old-fashioned schedule like that. Maybe there are situations where there's serious concerns about a parent's competency or safety or judgment. Some cases are more run-of-the-mill and some are quite serious depending on the situation. There are two kinds of guardians that you may work with. There are also guardians who are appointed in DSS cases, in child abuse and neglect cases. They are not typically attorneys. They may be volunteers who have been trained to do that work. They may be on staff with the governor's office that handles that, but they typically are not attorneys, and their role is the same as mine from an advocacy standpoint, but it's a little more limited. Whereas what I do somewhat, it kind of combines the role of the investigator, the caseworker, and the guardian and the guardian's attorney, kind of rolls it into one in a private case. I will also just mention, and we can talk about this more if anyone's interested and there's time, but it is also possible to be appointed guardian for a vulnerable adult. So I do, 98%, 99% of what I do is children, but occasionally I will be appointed guardian ad litem for an adult, either due to a physical, it could be something like Alzheimer's or a late stage cancer, and being unable to advocate, for themselves, or even attend court in some cases, or it may be serious mental illness, and so that does happen as well. So, fundamental roles of a guardian ad litem: 3: investigate, report, advocate. Those are the 3 things that I do. The way I look at the role is, my job is not to make decisions about this child. I'm not the child's parent. I'm not the judge. My job is to make sure that when a judge makes decisions, that he or she has good information to make decisions with. And so that involves investigation and involves reporting. The advocacy is a little trickier, and we'll talk some more about that. So for example, I had a hearing in court earlier this week where the sole purpose of the hearing was to receive my report. The parties had come into court earlier, and they had very different versions of events, highly disputed facts, a lot of he said, she said. And I'm paraphrasing, but the judge essentially said, I don't know what's really going on here. I'm going to appoint a guardian, and we'll come back and hear from the guardian and make further decisions. The judge did put in place a temporary order, of course, that left it open to come back and hear from the guardian and be able to reevaluate whether the temporary custody and visitation schedule was appropriate, with the benefit of my investigation and report. That's not an uncommon scenario. So it's the judge who will make the decisions, not me. So let's talk about how you might be involved. So maybe you're seeing a child already, and that child, one of those child's parents or some party involved, files a court case. So there may be a family court case that happens after you already have an ongoing relationship with the child. Or it may be that there is a custody case, and I might refer a child to therapy, or the court might order therapy. And so it may be a situation where you become involved after the fact. There's also situations where you might be seeing a parent. And so that is, I'm less likely to ever call you if you're seeing a parent. I don't in most cases. I mean, a really high percentage of parents, especially if they're going through the divorce, are going to be seeing a counselor. It's for their own support. If I don't have major concerns about a parent's mental illness, I'm very unlikely to ever contact their counselor. However, the cases where I would contact a psychologist or a counselor for a parent are where there are very serious allegations about the parent's mental illness and questions about the impact or safety of them as a custodial parent or even as an unsupervised visiting parent. In such a case, I would ask the parent to sign a release to allow me to speak with you. Obviously, we wouldn't do that without it, but they are typically cooperative. They are required by my court order to sign any releases I request them to. And they will, my personal practice, and I cannot speak for everyone else, but I will never subpoena your records. I'm not interested in invading anyone's privacy any more than is necessary to do my job. But I will contact you if there have been serious concerns raised about parents' fitness or safety to parent due to mental illness, and I will want to talk to you specifically about to ask questions that are very narrowly tailored to that issue, to those concerns. I'm never going to assume that the reason somebody is in counseling, I've had, it is my business. I mean, I've had parents who have victims of severe trauma, parents who've been combat veterans. There's going to be a lot of things they're talking about in therapy that are not my concern, but I will want assurance of whether somebody is compliant with treatment, whether there are serious concerns about whether they might be a danger to themselves or others, things of that nature. Most of the time, if I contact you, it's because you're seeing a child that I am guardian for. And in that case, we are on the same team. You and I are both going to be team child. And I hope that, that we can really work together in that way. And before I leave this, I'm looking at my notes, and I do want to go back and say, I'm not adversarial to anyone. So if I in any context, I'm not an adversarial party to any adult in the case. Now, I may take a position, I probably will take a position at some point, but I'm not in here trying to prove an agenda, right? I just wanted to figure out what's right for the child. I have a question from Susan.
Yeah. So when parents come into contact with a guardian ad litem, do they receive it like they do a DSS caseworker? Because often they're not happy about the DSS caseworker.
So the question is, when parents come in contact with a guardian ad litem, do they receive it as if it were a DSS caseworker, which might feel adversarial or feel threatening? Maybe not adversarial, but certainly threatening. Most of the time, no. I'm usually there because somebody or maybe both of them have asked for me. I try to work collaboratively with both parents. I try very hard to build a good relationship with both parents, even once I have taken a position that might be contrary to what a parent wants, or even after I've had to speak some hard truths sometimes, I still try very hard to keep that door open for that good relationship. And for me personally, the greatest, I will consider it a job well done, and this isn't always possible with personality disorders, but I will consider it a job well done if at the end of the case, if no matter what, if they both feel like they were treated fairly and heard, that I really listened to them and listened to their concerns and was straightforward with them. That's my hope in every case. And interestingly, sometimes people need to be and appreciate being called out. I kind of joke that I have two phases to my investigation. There's the fact finding, and then there's the truth telling. And so sometimes when I get to the truth telling phase, it hurts. But some people are surprisingly appreciative too. And I think my desire is always to speak the truth with compassion, and not in and in a way that preserves the relationship and focuses on, now, how can we correct this problem? How can we make it better? That's always my desire. Not always possible, but always my desire. Okay, so how can we help each other? So what I can bring to you, which may or may not be helpful to you in any particular situation, but I want to bring something to the table, and that is sometimes collateral information, sometimes context that might help you understand some things. One of the questions I received in advance, I think it's a good guide for how to approach the work I'm doing, is what information am I looking for? So when I call you, what information am I looking for? So by the time I call you, there's an open court case. I've been appointed guardian. I have received the parents' concerns. So I've spoken to them. They have told me, well, I'm concerned that mom is a yeller. She yells all the time. She can't control her tongue. She'll cuss at the child, or dad has no structure or routine at his house. There's no bedtime. There's no all just eating fast food. These kinds of things. These are kind of typical of the sort of allegations I might receive. So I know what the parents' concerns are, and I'm giving you more run-of-the-mill ones in that particular example. So, but there might be concerns about the parents' home, about the parents' treatment of the child, about the healthy relationship. what I am hoping for from the counselor is feedback based on your contact with the child and the child's communications to you about whether you share those concerns, you know, if the or others, right? So you will spend many more hours with the child than I ever will. I typically I might spend 3 hours with a child over the course of the case, and more in cases that are drag on and go to trial. Definitely not more, maybe even less in cases that are relatively run of the mill and resolved pretty quickly. But you have, and I will talk to the child, and I try to build rapport with the child, but you're going to have much more of an opportunity than I ever will to truly develop a relationship and trust, and to be, for the child to open up to you. And so what I'm seeking from you is either, or is refutation or validation of concerns. Obviously in my ideal world, when I talk to a counselor or to a child's teacher, what I'm going to hear is, they're both good parents, the child loves both, the child's happy to play with both, the child comes to school, clean and rested and well fed. I mean, that's what I want to hear, right? But that's probably not going to be the case if we're in here fighting for custody. But often I will talk to parents, I'll talk to a counselor, and the counselor will say, the child doesn't report any concerns about either parent. The child seems happy to spend time with both. That is reassurance for me, and that's very, very helpful. If everything you have to say is positive, that's very, very helpful to me. Maybe the child's experiencing some anxiety and just needs some help with coping skills because their parents are going through a divorce, but there's nothing alarming taking place in either home, and that's reassuring. That's my favorite phone conversation to have. Unfortunately, it's not going to be that way in a whole lot of the cases. By the time I'm involved, maybe other ones that y'all have, but certainly not if I'm involved, because I am in the most high conflict cases. But I understand you are not, your job isn't fact finding. You're there to work with the child on coping skills and emotional expression and self-awareness and those types of things. But you can bring concerns to my attention, and you can validate if, maybe the child is expressing mistreatment or is expressing other, concerns about something that's happening in a parent's home. And so, the other thing that I can do is I can take action based on your concerns. And I'm going to give you an example. Recently, I had a situation where a counselor was seeing one of my kids, and she and I had already communicated a couple times. Well, she called me because the child made a disclosure about something very concerning that had just taken place. She also reported it to DSS. It was a mandated report, and she appropriately reported it to DSS, but she also called me. And for reasons that are too complicated to get into, I was able to move much more quickly to take action on the child's behalf than DSS could in that particular situation. Sometimes it's the other way around, but in this case, and sometimes things might not be a DSS case, but I still can take action. Maybe doesn't rise to the level of child abuse or neglect, but it does involve a reconsideration of the visitation schedule. And so with that, counselors reaching out to me about what was reported to her or disclosed to her by the child, and her willingness to give a very detailed affidavit, we were able to get a parent's visitation supervised, which needed to happen in that situation. And I was very appreciative of the counselor's initiative and concern for the child. I will also say something else that she did very, very well was that she had already met with both parents at the outset. And so I do want to talk a little bit later about kind of best practices and about working with both parents. And the fact that she had done so before this concern ever came up increased her credibility. It made her affidavit less subject to any kind of impeachment or question about, whether, she's just only heard one side or, that kind of thing. So it was really a perfect example to me of how it should be done. And I was extremely appreciative. So, which leads to the other question that I've received in advance, which was, what does a guardian ad litem do with the information we received? Well, so in that case, I took action based upon it because it was information that rose to that level. That's not always going to be the case. A lot of times, sometimes it's going to go into a report. Sometimes it's going to just go into my head and stir around. Sometimes it's going to give me an action step I need to take. I received a phone call recently from a counselor that I work with regularly who said, "Oh, my kid just met you. She really liked you. And she also said that she didn't feel free to talk to you because she thinks it was being recorded." Mm-hmm. Well, I'm not going to say anything about that, but it's giving me something to investigate, something to look into. I can't go and put in a report, well, the therapist said, the child said, which we're going to talk about hearsay, and we will, because I can certain things, but not necessarily that. But that was one for me to just put into my head and be very watchful about going forward. So let me see. Let's see where I am on my outline here.
How do you get paid?
Okay, so Dr. Loring asked how I get paid. Excellent question. I get paid by the parties.
Okay.
And so when it happens.
Okay.
I do have my fees are court ordered, and so they are enforceable like a court order, just the same way child support is enforceable by court order. Gotcha. So people can be held in contempt for not paying my fees. I don't usually try to enforce them that aggressively while a case is pending, because again, I'm trying to remain non-adversarial. I want to keep a good relationship, but I can and will if I need to enforce them. Okay. But the initial order appointing me, this is a good question. I'll kind of go into this, and now I'm going to move on to the hearsays and HIPAA stuff. The initial order appointing me sets forth my duties under the statute. It also sets forth payment terms for me. It will typically split my fees between the parents, if it's parents, but not always. If there's a huge discrepancy in income, or sometimes one person will be ordered to pay more or all, regardless of who's paying. I want to try to do my job the same. I try not to do anything differently based upon who's paying me. I mean, it's sometimes when you have a situation where one person is supposed to and they're not, it's hard not to get a little frustrated with them about it. But I always just stay focused on I am under a court order to do a job, just like they're under a court order to get paid. And my job is for the child and for the court. And, unfortunately, sometimes I just have to figure out the payment later and set that aside, put it in a little box and set it aside and focus on doing what I'm ordered to do, whether they do or not. But that is how I get paid. So the order appointing me, and let me also, because one of the questions I had was about how you get appointed. If the attorneys for the parents or other parties may agree to appoint me by consent, or I may be chosen by the judge. Either way, but I cannot be hired by the parties. I've had people contact me before and say, "Oh, I'd like you to be a guardian ad litem," and I say, "Sorry, it doesn't work that way. You cannot choose your own guardian ad litem. Your attorney can, if you have an attorney, they can ask for me, but it's up to the court who to appoint, and ultimately the judge decides." I do not know if they kind of randomly go down a list, or if they are a little more strategic about who they think is a good fit for a case. I honestly don't know. I know that if the lawyers agree on it, I know that they've given thought to who they might want and why. But if the judges do it, I honestly don't know. Never asked that question. So, but there's not a huge pool of guardians in our community. There's a relatively small group of us who do primarily or solely guardian work. And then there's a few other people who do some while also doing litigation. But I'm one of the ones who doesn't do anything else. Okay. The other thing, I want to go back because I forgot to say this, but I had made a point in my outline to mention the other thing that I really appreciate about having a relationship with a child's therapist is that if we are on the same page, if we see things the same way, it is a huge confidence booster for me in terms of feeling sure that I'm seeing things correctly. And especially in some of these really difficult cases, and especially in some of the cases where there's just really difficult people involved and a lot of deception, and I'm not sure who's the one playing the mind games and who's telling the truth. If the therapist and I see it similarly, it definitely makes me feel more confident in what I'm doing, that I'm not wrong, I guess, so that's also really helpful. Okay, so I want to talk a little bit about hearsay and HIPAA. Let me start on the HIPAA side. My order authorizes me, the court order that appoints me, which I will send you anytime that I reach out to you. It authorizes me to access the child's private health information. It authorizes me to meet privately with the child, school records, medical records, anything of that nature. Now, in my opinion, that's enough. That's in my opinion, that is and should be all you need to be able to talk to me. Some people disagree. Some people don't feel comfortable unless they also have a release by a parent. I can't really argue with that because there's no harm ever in having a release too, and you're covering your own back. So I can't really argue with that. But I do have a court order that allows me to access their private health information, which I think is arguably the equivalent of a HIPAA release.
And I'm that person who's going to want my own release from my client. And part of what that does for me is it builds their trust in what I say.
Well, and so Susan made the point that she's someone who always wants release from her client. And let me also clarify, I'm not talking about adults, I'm talking about children. So yeah, and Susan says part of the reason is because it builds trust for her to have a release. I 100% agree with that. And I will also never contact you about an adult without a release by your client. I would have your client sign a release. But a parent, I don't know that a parent needs to sign a release to allow you to speak with me about the child, but it's not a bad idea. It can never hurt to have that. And so, unless there's a real urgency, that there's no harm in doing that for sure. And the other thing to remember is that both parents have a right under the law to their children's medical records. And so even if they don't have custody, they have right to access them under the law. And so really, I think either parent could release those. I do, again, I don't subpoena people's records. I don't ask for your records because I just want to talk to you. Not everybody feels that way. I know other people do request records, and I certainly cannot promise you that the lawyers who are adversarial will not subpoena your records or subpoena you. But I can only say what my practice is, and I think most guardians like me really want to have good collaborative relationships with the local counselors, and so most of the time, I think most of us prefer to just have a conversation, but I can't speak for everybody, and that may not necessarily be the case. I think one of the most important things that you can do when you have concerns about a child is to provide an affidavit from me if there's a hearing at which I'm raising those concerns. Having a therapist affidavit can be extremely important and helpful. So it's not just me showing that we're on the same page, we share this concern. It's maybe something that doesn't matter as much if there aren't serious concerns, but if there's serious concerns, it can make all the difference in the world to have that therapist affidavit that is detailed. So I want to talk a minute about hearsay in that context of your affidavits, if you provide them, or or testimony if, God forbid, you're ever required to testify. I hope it very rarely gets to trial, very rarely. Most cases, and you can kind of help it not by providing information along the way, right? But so most people are familiar with the general concept of hearsay. Basically, you can only testify to what you have personal knowledge of, right? That's the basic concept, not something you've heard from somebody else, but what you actually have personal knowledge of yourself. But there are a lot of exceptions, and one of those exceptions is statements made for the purpose of medical diagnosis and treatment. There was some, I think it's been widely assumed for a long time that applies to counseling, statements made in counseling, but not necessarily by everyone. A couple years ago, our South Carolina Court of Appeals did issue a written opinion that specifically stated that statements made to a therapist for purposes of diagnosis and treatment are fall within that hearsay exception. So it doesn't mean necessarily everything a child says, but it does give us some wiggle room, I guess, and some protection there. And I have not really had anybody. I don't think I've ever had anybody object on hearsay grounds to a therapist affidavit that I've tried to introduce. I don't think I have. And I try to be careful if I'm concerned about what's in it, to work with you on that to make sure that it is admissible, or at least that we have a fighting chance. But I have not really had, I don't think I've ever had anybody object to a therapist affidavit. And so the other thing interestingly, this is as an aside, the other thing that particular Court of Appeals case ruled was that the court could not authorize a therapist to decide when, for example, visitation would begin, or like what I think in that particular case, it had been like the case had been closed, leaving it to the therapist's discretion. And the Court of Appeals said, no, it's in the court's discretion. The court cannot defer that to a counselor, which was an interesting decision. So, the way I try to phrase things, and of course it's definitely, while a case is open, is that I will confer, I will get recommendations from, and then if the parties agree with the recommendation that the therapist and I make, great. But if they don't agree, they have a right to take it to the judge.
I just wanted to know, you mentioned that was about authorizing visitation.
Mm-hmm.
What about reunification therapy?
And that may have been what it was. I have the case here, and I don't remember the exact details of what they said was inappropriately left to the discretion of the therapist. Here we go. It is visitation. It says the family court erred in ordering father could only have visitation when and if his counselor and someone else, I'm not sure who this other person was, if it was the child's therapist or someone else, but when and if they deemed it appropriate. Deciding issues related to the best interests of children is of the exclusive authority and responsibility of the family court, not third parties.
So would that mean basically potentially the case would have to remain open?
It will not remain open. They will
Okay.
close it, but there would have to be some other mechanism that doesn't delegate that responsibility. They would have to have a mechanism that, allow them to come back to court, or that, something of that nature. Because the cases, they're going to close the case within a certain period of time. They're not going to leave it open. But I think sometimes these things have been closed with, like, delegating it to the therapist was a way to try to avoid having to go back to court. And I think with the Corsairs, you just can't do that. And I apologize. I did not give the question. I did not repeat your question. So people on Zoom didn't hear the question. The question was about what exactly was it that could not be delegated to the counselor. For those who are interested, this case is Glenn Yanay, Glinyanay versus Tobias, and it's a 2022 decision, and it was argued by one of the parties, by our own Ken Shabel, who many of you know. Yeah, he'd like to represent one of the parties on appeal. So, okay. Let me see what else we wanted to cover. Okay, I want to talk about best practices. First off, being willing to work with both parents in contested cases is extremely important. I cannot tell you how many times I have seen a therapist removed, replaced during the course of litigation. So here's a child who has developed a relationship with a counselor, developed that therapeutic bond, and they have to change counselors because a therapist is perceived as being biased or because they had come out with, given an affidavit or expressed opinions and had never met with one of the parents. As a practical matter, I can see why this is really hard. Somebody comes into your office, they bring their child, they have the authority to get counseling. It certainly isn't your responsibility to reach out to the other parent. But I do think there's some things that you could do to kind of set the appropriate tone from day one that might help with this. And I'd be interested in hearing your feedback on this as a practical matter, kind of how you guys feel like this could work. But my perspective is, number one, ask some screening questions, and I don't know what all you all have in your intake already, but thinking about, are you married? Who else is living in the home? Is there a custody order in place? Is there court involved in some way? A lot of that might come out naturally, but it's good to ask the question. Does the other parent know you're here? I know there are some people who will not see a child without both parents signing consent unless one parent clearly has sole custody. They have court order giving them sole custody. But even if it's like a joint primary situation or there's no existing order and they're married, it's good to think about. I don't even know what to tell you. I don't know what I would advise necessarily, and that's not really my role here in this conversation to advise, but it's something to really think about in terms of kind of the tone and expectation you set from day one in terms of openness and transparency when it involves both parents. And so, because there are parents, and lots of them, who will weaponize you against the other parent. That is their goal. There are parents who will bring their child to therapy as a weapon in their case. They want their child to come in and disclose things to you. They want the child to come in and tell you things that they can then turn around and use in their family court case. And one of your best protections against being misused in that way is just being on guard about it, alert to it, asking the right questions, and setting the expectation, at least, that you would want to communicate with both parents. Absent unusual circumstances. There certainly are circumstances where you wouldn't, or there may be circumstances where you do, and then you have to stop it because that parent's abusive to you or disruptive or things of that nature. But an openness to working with both parents, I think, is really, really important. It's going to be important to your credibility. It's also going to be important to protecting your ongoing relationship with the child, so that the child doesn't have to change therapists because of perceptions. And so, I've got one going on, therapist number 3, and it's just, and there's games being played, and it shouldn't be like that, So you can protect yourself and the child, I think, by doing some, at least screening for that, and by, it's up to you whether you want to have a practice where you actually require the other parent, or at least reach out to the other parent, but certainly signaling openness to that from day one, I think, is really important. I'm interested to hear how people handle that. So.
Well, I've been trying to do this a while. I don't know compared to other people, but I've made a lot of mistakes and I've learned a lot along the way. So I'm pretty good at sniffing out if somebody wants to use me. And will avoid that sometimes, but other times, if I am going to see a child whose parents are in the process of getting divorced or there's some kind of custody situation, I definitely reach out to both of them and let them know if they don't know, and just kind of try and pull the both in.
So Dr. Loring is saying he reaches out. He reaches out to if he thinks that there's that kind of a custody situation.
Oh, and I'll ask them right from the start. I'll say what's going on. I mean, I'm very frank with them, you know. And you know, because sometimes people will call, I want my kid to come in for counseling, and they don't talk about everything else going on, you know. But I think you can usually kind of figure it out with if you ask some of the right questions.
And I think asking the right questions at the very beginning is exactly the key, because
yeah, and one thing, if it is a situation like that, I tell both parents, I am not in a position where I'm evaluating you as parents, but I will see your child. A lot of times I'll draw that boundary, and that's been very helpful for me, because then if I have to work with a guardian or if I get subpoenaed or I've been all of the above, I'll say, listen, I'm not evaluating this parent. Now, if I'm concerned about something a parent is doing, then I'll certainly do something. But oftentimes, there's nothing particularly concerning going on, like a sort of situation where you have to report something. But I definitely, from the start, say I'm not evaluating you as a parent. If you want to bring your kid to see me, great. And that's been very helpful too.
So Dr. Loring is also saying that he makes a point of saying, I'm not evaluating you as a parent. I'm going to work with your child. You know, if there are concerns that require being addressed, you know, I think if you're working with a child, you may be doing some. You're also going to be doing some working with their parents, right? And a little coaching and co-parenting and parenting skill building and all of those things. But drawing that boundary that this is what my role is, this is what my role is not,
right,
at the outset.
That's been helpful.
I will say in my phone consultation form before they can come in, I have what is your custody situation as one of the questions, just so that I know going into this. And if there is a custody battle, I will tell parents. In most cases, it is my opinion that the child needs both of their parents in their life, unless there's something extreme happening. And that way, if it's petty things, they know either they're just not going to want me because I'm not going to take sides, or if there is something extreme, then I may be the right fit for them.
So Erica said part of her initial screening is asking if there's a custody, what your custody situation is, and expressing at the outset that absent extreme circumstances, it is in the child's best interest to have both parents in their lives, and just sending the message that the petty stuff, you know, she's not going to be weaponized in that way. I may have not expressed that. Okay.
Yes.
Yeah. Yeah. Because a lot, you know, a lot of it is petty stuff, and then there are serious things, and sometimes it's hard to know exactly where that line is or where the cumulative effect of the petty becomes serious. And that's, you know, I do, from my perspective, I completely agree with what was just said about it is most of the time it's going to be in child's best interest to have both their parents in their lives. And the question is, what are the, you know, what's the schedule going to look like? Are there concerns with a parent's parenting skills that can be addressed, that we can make better in some way? I mean, I always want to try to make it a little bit better. If we can make it a little bit better, sometimes you can't, and sometimes there are situations where, you know, where a parent's contact should be non-existent or extremely restricted. That is not most of my cases. I am not in the severe abuse and neglect cases. Those are happening in the DSS realm. They're not happening in private custody battles very often. There may be minor, I hate to call any abuse minor, but there may be minor, you know, concerns that are abuse and that are neglect, at least arguably, or concerns that don't rise to a level that it would be considered abuse or neglect by DSS standards, but it's still concerning and still goes to parental judgment and capability. And there's plenty of that in the private cases. And to me, those things are best addressed through a schedule that may put the child primarily with one parent, kind of lessen the time with one, or with restraining orders, which are not always easy to enforce. But I've had parents where there were concerns about excessive corporal punishment. We've had court orders that will just not allow any corporal punishment. Where there's been concern that it's, I personally am not in favor of corporal punishment at all, but I also know that we live in a place where it is still widely exercised, and there are plenty of judges who think it's appropriate. And so, if it's being, although I personally do not approve of it, if it does not cross a line that would be considered excessive by what I understand to be the prevailing standards and the guidelines of DSS, and the way my understanding of how some of the more old school judges approach it, then there's not much I can do about that, because I'm not the super parent here. That's not part of my job. I can't. That isn't my role to tell them how to parent. But if there's situations where there's concerns about it being used inappropriately, I have seen the court approve a request from me or from the other parent to prohibit it completely.
I don't see any, just checking. I don't see anything in the chat or in the Q&A, but feel free to put questions or comments in there.
Yeah, and I know I'm about to wrap up, so if you have questions, I've almost said everything I want to say. I do want to say that I really understand why counselors may be reluctant to get involved in cases that involve, where there's any kind of contested custody case. I'll answer that in a second. Where there's any kind of contested custody case, so there's any sort of court involvement, I get it. Number one, we're dealing with often very high conflict people. It is the absolute hardest part of my job, is dealing with high conflict people and keeping my own center, keeping my core when I am under attack or when I'm just exhausted by them. And there's people who I just feel like stick an IV in my vein and draw the blood out every time I speak to them. And so that part's very hard about it. And then there's also the fact you're subject to subpoena, your testimony, your files. You get cross-examined if you're put on the stand. There are lawyers who will be aggressive with you. I get why people don't want to have anything to do with it. And I have seen really good counselors get very badly burned by this system and not want anything further to do with it, and I get it. Having said that, if you are going to work with children, this is going to be part of your job. And I can only tell you that if you work if you work collaboratively with the guardian ad litem, I do think I can speak for most of my colleagues and say we will try to protect you. Like we need you, we appreciate you, we value what you do, we consider us to be partners with you in protecting these children, and and it takes a little courage to put yourself out there, such as in an affidavit, but I think it is necessary part of the job if you're going to work with children, because even if you don't take cases that have an active court case, you cannot guarantee that you're not going to be seeing a child and somebody file, and then the case is there. And I'm grateful to all of you and what you do. And really, I appreciate you. Okay, so I have a question. Do you have to be an attorney to be it says a paid guardian ad litem, a private guardian ad litem? The answer is not necessarily. So I'll tell you a little bit about the process for becoming a guardian ad litem. There is a statute that governs private guardians ad litem and who is qualified. There is an annual training that is required. It is done the last Friday in January every year. I attend that every year to keep up my skills, and I don't know that it's required to attend that exact thing. It can also be, done virtually, but I don't know. There has been in the past a training done for lay guardians through the Children's Law Office at USC. I don't know if that is active currently. There are a very small number of lay guardians that get appointed consistently. I know of one in Spartanburg, maybe two. I think there's an opportunity for another one if she wants to do it because of her experience. There's at least one that I know of in Greenville. There may be more. I know there are more in some of the smaller counties, but I will tell you, our judges locally have been reluctant to appoint lay guardians for a couple of reasons. One is that as a non-lawyer, you are not subject to their discipline. And so now as a therapist, if you're a therapist interested in doing this, you have a disciplinary board. That may make a difference from the judge's perspective. But, I am subject to discipline because of my law license. And so that is one reason why the judges like having a lawyer. Number two, I often do have to file motions, and it's unauthorized practice of law for someone who's not a lawyer to do those. And then you can be in a situation where where the guardian needs a lawyer, and who's going to pay for that? And so that has been an obstacle for some people. Jean Bradley does get appointed regularly in this circuit because of her reputation from years running the volunteer guardian ad litem office. And she would be a good person to talk to if you are interested in doing guardian work as a layperson. Are there other questions? I don't see any others.
Is there a way to know
Hold on, one live.
when you get a custody order that is the most up-to-date custody order?
Okay, so the question is, if you receive a custody order from a parent, is there any way to know that it's the most up-to-date? That is a really good question because people can be really tricky. Yes, they can be so sneaky. There is a public portal through the SC Courts website, sccourts.org. There is a public portal, but I don't know that that would necessarily tell you what you need to know. I would always tell you, if there's a guardian ad litem listed in an order, always feel free to call them and they can tell you. But if there isn't, I don't know that there is going to be an easy way to find that out and be confident about it. Yeah, I mean, you can check through that public portal, but it may not be clear to you. Yeah, that's a really good question. And people can be so sneaky, y'all. I mean, I was actually talking to a therapist this morning who had told me that one of her recommendations was to ask for ID because people will pretend to be somebody they're not. Dad's girlfriend comes in pretending to be mom, and I don't know how far you'll have to go or maybe you just have your spidey sense, so you check, ask for it if you have a reason to have a little bit of red flag. But yeah, people's capacity to be sneaky never ceases to amaze me. I've even known someone to make an appointment with a therapist without disclosing that their child's other parent was a client, an active client of that therapist, in order to get in and talk to the therapist. Yeah, can you imagine? Meeting with someone and having them telling you all these things about their child's other parent, and finding out that not only is that other putting together that child's other parent is your active client, and they came in there with an agenda to give you all this information. The human capacity for deception is shocking to me. I'm 51 years old, and I'm so naive. I still am shocked when people lie to me. And I don't know why, because people lie to me every day, but it still shocks me when people lie to me. Right. Unless there's something else, I think that's it. It's been really nice talking with you all. Thank you for participating. Andrea, I'm Andrea Moore. Google me if you want to reach out and ask any other questions or talk to me about any of this. And I'm happy to speak with any of you. Okay. Thank you.
Thank you, Andrea. I put in the chat the Survey Monkey for continuing education. If that's something that you're interested in, you can just click on that link. And if you have any other questions at all, just email us at info@mhaspartanburg.org. Thanks so much.